Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Daniel Talluto, Troutman, J. The Sex Offender Registration Act provides for two circumstances in which a person convicted of an offense in another jurisdiction must register as a sex offender. One circumstance is if the offense satisfies an essential elements test, i.e., the offense includes all of the essential elements of an enumerated sex offense or sexually violent offense. The other is if the offense falls within SORA's foreign registration requirements, i.e., a felony in any other jurisdiction for which the offender is required to register as a sex offender therein. The issue here is whether Section 168A, 3b, requires any person subject to SORA's foreign registration requirements to be designated a sexually violent offender regardless of whether the underlying offense is violent in nature. We hold that it does. 1. In 2012, defendant was convicted in Michigan of criminal sexual conduct in the first degree, a felony that required him to register as a sex offender under Michigan's Sex Offenders Registration Act. See MICHCOM clause. A person is guilty of criminal sexual conduct in the first degree if he or she engages in sexual penetration with another person and that other person is at least 13 but less than 16 years of age and the actor is related to the victim by blood or affinity to the fourth degree. In 2020, defendant relocated to New York to live near family. The Board of Examiners of Sex Offenders, Board, pursuant to Correction Law Section 168K, determined that he was required to register as a sex offender due to his felony conviction, which requires registration as a sex offender in Michigan. The board completed a risk assessment instrument, allocating 65 points to defendant, making him a presumptive level 1 risk. The board recommended that county court adjudicate him as such with no sexually violent offender designation. Defendant and the people agreed with the recommendation. However, the court concluded that the plain language of Correction Law Section 168A, 3b, required it to designate defendant a sexually violent offender because he was convicted in Michigan of a felony that required him to register as a sex offender in that state. Although the court believed the result illogical, it concluded that any error or perceived injustice in the statute was a matter for the legislature. The appellate division affirmed, with 2 justices dissenting. The majority concluded that subdivision 3b plainly and unambiguously required county court to designate defendant a sexually violent offender, although it added that the result was illogical and unfair and that there was a compelling case that subdivision 3b's foreign registration clause was the result of a legislative drafting error. The dissenting justices concluded that applying the foreign registration clause would lead to an unreasonable if not absurd result, i.e., the designation of defendant as a sexually violent offender when the underlying felony was a non-violent offense. Defendant appeals as of right by virtue of the 2-justice dissent, CCPLR 5601, A. 2. Defendant contends that the insertion of subdivision 3b's foreign registration clause was a legislative drafting error, and that the legislature did not intend for non-violent offenders to be designated as sexually violent, a result he considers absurd. We reject that contention. Defendant's proposed construction of subdivision 3b amounts to a request that we read the foreign registration clause out of the statute entirely and fail to give effect to that portion of the statute. We note at the outset that, although the amicus brief sets forth an argument that the statute is unconstitutional, defendant did not preserve any challenge to the constitutionality of subdivision 3b's foreign registration clause, nor does he raise any such challenge on appeal. The sole issue before us is one of pure statutory interpretation and, therefore, our task is to ascertain the legislative intent and construe the pertinent statutes to effectuate that intent. People v. Roberts. We begin with the statutory text, which is the clearest indicator of legislative purpose. Matter of M.B., Simayevsky v. Broadalbin Perth Cent. School Dist. Effect and meaning must, if possible, be given to the entire statute and every part and word thereof. McKinney's Cons Laws of NY, Book 1, Statutes Section 98. Where the language of a statute is clear and unambiguous, courts must give effect to its plain meaning. Words are not to be rejected as superfluous. Matter of Tall Trees Ginster. Corp. v. Zoning BD. Of Appeals of Town of Huntington, see Matter of Anonymous v. Malik. Any sex offender must register as such pursuant to SORA's requirements. Sex offender is defined as any person who is convicted of any of the offenses set forth in Subdivision 2 or 3 of Section 168A. Subdivision 2 sets forth a list of criminal offenses in paragraphs A through C that constitute sex offenses. Subdivision 3 sets forth a separate list of criminal offenses in paragraph A that constitute sexually violent offenses. Only those persons convicted under Subdivision 3 of a sexually violent offense warrant the designation of sexually violent offender. Subdivisions 2, D, and 3, B, encompass out of jurisdictions convictions. Sex offense means a conviction of 1. An offense in any other jurisdiction which includes all of the essential elements of any such crime provided for in paragraph A, B, or C, of this subdivision, or 2. A felony in any other jurisdiction for which the offender is required to register as a sex offender in the jurisdiction in which the conviction occurred, or 3. Enumerated federal crimes. Sexually violent offense means a conviction of an offense in any other jurisdiction which includes all of the essential elements of any such felony provided for in paragraph A of this subdivision, or conviction of a felony in any other jurisdiction for which the offender is required to register as a sex offender in the jurisdiction in which the conviction occurred. The statutory language is clear and unambiguous. A felony in any other jurisdiction for which the offender is required to register as a sex offender therein is, under Subdivision 3, a sexually violent offense. As a general rule, unambiguous language of a statute is alone determinative. Riley v. County of Broome. However, where the plain meaning of a statutory provision leads to absurd or futile results, this court will look beyond the words to the purpose of the act. New York State Bankers Association v. Albright. The history of the statute reinforces the clear meaning of the text. The legislature enacted SORA in 1995 in response to an act of Congress that conditioned federal funding on states establishing sex offender registries, CL 1995, CH 192, People v. Diaz. SORA, in its original form, encompassed out of jurisdiction convictions of only those offenses that satisfied the essential elements test for a sex offense or a sexually violent offense. There was no foreign registration clause. In 1997, however, Congress added a reciprocity requirement, directing states to require sex offender registration of residents convicted of offenses in other states that fit within the federal scheme, CDAs. In 1999, the legislature responded by amending the definitions of sex offense and sexually violent offense to add the foreign registration clauses. The Governor's Program Bill Memorandum makes it clear that the language was added because the essential elements test was deemed to be non-compliant with the recent congressional directive, CL 1999, CH 453, Governor's Program Bill Mem No. 116 at 6. Failure to expand the list of registerable crimes as required by federal law could result in the loss of 10% of the state's burned formula grant. The memorandum explained that the then existing statute require a detailed analysis of the statutes in other jurisdictions to determine whether registration is required in New York State. The bill sets forth a clear method to determine whether registration in New York State is required. If registration is required in the jurisdiction of conviction, registration will be required in New York. The memorandum also contained a summary of each section of the bill, which specifically addressed the amendment to Subdivision 3B. Section 1 amends Paragraph B of Subdivision 2 to include within the definition of sex offense a conviction in another jurisdiction of a felony which requires the person to register as a sex offender in the jurisdiction where the conviction occurred. Section 2 amends Paragraph B of Subdivision 3 of Section 168A of the correction law in the same manner as the amendment to Section 168A, 2, B, with respect to a conviction for a sexually violent offense in another jurisdiction. The identical language in the definitions of sex offense and sexually violent offense with respect to a felony in another jurisdiction raises certain issues. The definitions do not otherwise overlap. Nor should they. A person convicted of a sexually violent offense is a sex offender subject to all the same restrictions and requirements as a person convicted of a mere sex offense, as well as additional ones, such as lifetime registration regardless of risk level. Practically everyone involved in this case from its inception, defendant, the people, the county court judge, all 5 justices at the appellate division, including the justices in the majority and the dissent, and apparently the Board of Examiners of Sex Offenders, agree that the statute is problematic as applied to defendant. The Advisory Committee on Criminal Law and Procedure to the Chief Administrative Judge of the Courts of the State of New York has concluded that Subdivision 3, B.S. Foreign Registration Clause was added in error and, accordingly, has recommended every year since 2010 that the legislature delete it. The committee has observed that, because Subdivision 3, B.S. Foreign Registration Clause is identical to its 2d counterpart, the statute collapses the distinction between violent and non-violent sex offenses, at least as it applies to out-of-state offenders who reside in New York. Report of the Advisory Committee on Criminal Law and Procedure to the Chief Administrative Judge of the Courts of the State of New York, January 2010 at 17. Indeed, the Governors and Senate introducers' explanations for the addition of the clause, as relating to a conviction for a sexually violent offense in another jurisdiction, suggests that the legislature may have intended for Subdivision 3, B.S. Foreign Registration Clause to have a more limited effect than its plain language compels. As the amici suggest, the legislature may have meant for Subdivision 3, B.S. Foreign Registration Clause to apply only to an offender who is required to register as a sexually violent offender in the jurisdiction in which the conviction occurred. Yet, as the amici acknowledge, this construction is itself problematic because, unlike SORA, the registration laws of certain states do not include a category of offense designated sexually violent offenses. In fact, the term sexually violent offense does not appear in Michigan's sex offender registration law, see MICHCOM clause. Moreover, if the wording of the statute has created an unintended consequence, it is the prerogative of the legislature, not this court, to correct it. Matter of Lisa T. v. King et. Although select ambiguous language in the legislative history provides some support of defendant's argument, the plain language of the statute is not ambiguous, and thus we are bound to follow it. See Matter of Auerbach v. Board of Educ. Of City School Dist. Of City of NY. Defendant, and the many learned judges, lawyers, and legal scholars, may well be correct that Subdivision 3, B.S. Foreign Jurisdiction Clause contains a legislative drafting error, but that does not give the courts license to ignore it. Courts must not legislate under the guise of interpretation. People v. Finnegan. If we were to take it upon ourselves to delete Subdivision 3, B.S. Foreign Registration Clause as the committee suggested the legislature should do, we would be impinging on the province of the legislature. See People v. Gottlieb. Thus, we are constrained to construe Subdivision 3, B.S. Foreign Registration Clause according to its plain language. If the legislature did err, we unequivocally call upon it to remedy that error. 3. Contrary to defendant's alternative contention, adopted by our dissenting colleague, the decision whether to designate a defendant a sexually violent offender is not a matter with respect to which the adjudicating court may exercise discretion. Sexually violent offender is defined as a sex offender who has been convicted of a sexually violent offense defined in Subdivision 3, Correction Law Section 168A, 7b. The court is bound by the statute. See People v. Bullock, People v. Lockwood. To be sure, an adjudicating court in a SORA proceeding has the discretion to grant a party's request for an upward or downward departure from the presumptive risk level. That authority, and the procedures for assessing the defendant's presumptive risk level in the first instance, are derived from SORA's guidelines. See People v. Johnson, citing Board of Examiners of Sex Offenders, Sex Offender Registration Act, Risk Assessment Guidelines and Commentary Act 4, 2006. See also People v. G. Lodi, which the Board is empowered by to create pursuant to Correction Law Section 168 Liter, 5. Conversely, Section 168 Liter 6 does not explicitly or implicitly bestow discretion on the courts to depart from a sexually violent offender designation. That section sets forth only the procedure for SOR adjudications, describing how after the board indicates whether a defendant is a sexually violent offender, a court conducts a hearing in which it reviews the board's recommendations and officially pronounces the defendant's designation. Bullock, it does not provide the courts with the discretion to disregard the legislature's unambiguous statutory definition of sexually violent offender. 4. County court properly determined that it was required by law to designate defendant a sexually violent offender because he was convicted of a felony in another jurisdiction that required him to register as a sex offender therein. See Correction Law Section 168A, 3b, 7b. Accordingly, the order of the Appellate Division should be affirmed, without costs. Order affirmed, without costs. Opinion by Judge Troutman. Acting Chief Judge Canataro and Judges Rivera, Garcia and Singas concur. Judge Wilson dissents in an opinion. Decided December 13, 2022.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law